We talk to the official spokesperson for the Judiciary of Sierra Leone, Moses Lamin Kama, where we can talk about the criminal session we don't start and some of the issues them where they happen at the Judiciary. Good morning, Moses, and welcome to Radio Democracy.
Yeah, good morning, Usman, and good morning to the listening audience.
This being term, we see we are in the President, Dr. Julius Madabio, appoint Justice Combat Commander for be the new Chief Justice of the Republic of Sierra Leone. But firstly, waiting done they happen so far at the Judiciary under the leadership of Justice Combat Commander since where they appoint him?
Well, we want to tell people and say a lot's done they happen inside the Judiciary since his appointment. We want to let people know say the Honorable Justice Combat Commander now one of the oldest judges there in terms of he has spent within the building, because he came in as a magistrate and in go for magistrate High Court, Court of Appeal, and at Court of Appeal he was also a senior judge at the Court of Appeal when appointed by the President for go na the for all the highest position na the Judiciary when na the Chief Justice. And also currently he is also the most senior judge, because by virtue of the Constitution, once you become the Chief Justice, you are the most senior judge in the Judiciary. So he is the most senior judge in the Judiciary. So a lot done they happen. Let me say where Honorable Justice Commander come inside, you discover say on just outline them in first interaction with the public now for issue out a bill directive, and for we in very, very significant than any infrastructural development when it comes to the Judiciary, because we mandate now for ensure say we deal with people them with and in a prison, we deal with cases them, we ensure say everybody in rights be respected. And when you look at the issue of bail, for him as a clear vision is that bail nothing we will for the give out to people there, hence the necessary conditions are met, not enough for make somebody for going to prison as a result of bail. You understand? So it encourage every magistrate and judges that let them try for give bail as best as possible. But also now a person will get respect of the law, because in the work in accordance with the bail regulation and also the portion in the Criminal Procedure Act we say bail should be granted for all offenses, but like for the major one them now a judge for grant bail. So it encourage in staff them, more especially the judges and magistrates, that bail should be granted. And when bail should be granted, in directive also say anybody in our judicial staff when they partake into the bail process must ensure that the bail process for be carried out without any hindrance. For say you deliberately stop for let somebody go na cell or you go sleep in a prison because of your own contribution where the person don't play in your part. So a lot is happening, and for ensure that we carry that effectively and accurately, you not only give the directive, but in set up a committee. One, we know say it is common in the magisterial courts where you see them go give bail at around 4 o'clock. By the time where the person they go for go get them documents them, the person don't go down na prison, which could be the ultimate aim of the complainant. We see them things that they don't be to a stop, because in say one, this directive from 12 to 1. Now the 10 down they wait there for the process bail. So if it starts from 12 to 1, you go there from 12, 1, 2, 3, 4.
Okay.
So at least you for don't meet up. And if you then grant bail at around 2, 3, they ensure say the DAI will for sign and approve the bill, or the master then for be the last person where they left the court premises. In each of we court premises then the masters and they can left late or the DAR. Okay. For ensure say any bill where they grant that day for be signed and approved, and then give, if they don't late, they don't go the image there a production order where you present at the prison gate, then they release the person to you. Okay. So it don't put them things steady, and it also don't put a monitoring mechanism. That is to say, judges have been appointed at various levels in the Judiciary. you get senior judges them where they look at the Supreme Court in cases them assignment of cases they look at them. You get judges at the appeal court, you get a Supreme Court judge, they supervise the appeal court judge. You also get judges them at the Court of Appeal, like for instance we get Justice King and Justice Barnett. Then they supervise the entire magistrate court all over the country, and they're also responsible for assignments. So in system of leadership currently is that everybody is involved.
Okay.
Everybody is involved.
All right. Now, it's over 3 months now since we appoint them for all the position there, and one of envision them now for CC the bill issue, then try for look into a proper, and most of the issues them where you discuss they happen at magistrate court. We are in some man go there something just for phone, then send and down. Sometime back we hear a story we are in then jail somebody for paper. I think close to 5 years. Now you mentioned about again about monitoring aspect. Wetin go happen if una find out say the judge the magistrates them they send people down just for common crime and they refuse them bail?
Okay, besides the administrative decision where the Honorable Chief Justice or any supervisory judge gets right for take, because notwithstanding we get the legal aspect where if a magistrate, like for instance, sentence somebody for minor offense, we discover say the thing where the person do is not commensurate, because we get what we call judicial fairness. The Honorable Chief Justice also in section 17 cap 17 of the laws of Sierra Leone and get what we call and get the power for do what we call judicial review, wherein they send a high court judge in any part of the country for go look the sentences and the bail condition where magistrate do not impose on various individuals them and not undertake it than it since we in camp, but I no say in get for undertake them, because now one of envisions then than they we intend for do. So the judge where they go get right for squash some sentences of the magistrate if he feels say it's unfair, and if he feels say the magistrate give a sentence with the out of a mandate, he can squash them. But notwithstanding that, we they ensure say any directive where the Chief Justice don't give, we are bound for ensure say we carry them out. As it is, we not get complaint of any, because I'm also part of the monitoring mechanism. The communication team is part of the monitoring mechanism. We not get complaint it, but we want to encourage the public, because that is why he is reaching out to the public through the communication team. We they communicate in vision, in intention, and what he plan to do.
Let me continue for watch at the Chief Justice in Vision since he came to office. My colleague asked you at the start of the program in Vision, he started for talk about how it modeling itself for ensure say bill happen I suppose for happen according to the law. And let me move away from that one there. Watch out the judiciary get wide scope. I mean, low watch out with no intention and vision when it comes to making cases not delay as it don't normally they happen. Cases in the court don't take years. 1, 2, 3, 4 years. Anytime when I go now, adjourn. What are the vision of the Chief Justice on that one day?
Okay, the Chief Justice gets control in the first place when it comes to the administrative structure of the judiciary. Mind you, if you watch at the Constitution section 120 subsection 1, it tell you say the Chief Justice now the head of the judiciary. So in constitutional power is on the judiciary. You understand? You go to section 122, it deals with the cases then where we deal with, and 3 talks about the independence of the judiciary. Now the Chief Justice gets a very clear vision when it comes to the issue of cases then, and when it can communicate in vision to the judges, the magistrates, as well as the support staff then. This now in vision, one for ensure say people then rights be adhered to when it comes to the issue of bail, because this now in statement and say waiting it go profit or waiting we go see if somebody where them for be don't grant a bail, we refuse for give bail, then at the end of the case that person is not found wanting or there is no compelling evidence for conviction, then you keep the person in prison throughout, then at the end of the day you not convict them. So a vision is to, and a message to every judge and magistrate, that it is safe for let we grant bail. We conscious go serve we well for let we grant bail when it comes to dealing with the matter, but when it comes to sentencing, equally let we sentence accurately. That now in broader vision. Now the issue of cases delay, it all depends how people then determine her or how they define her. You understand? The Chief Justice don't put up a mechanism. One, he happened for be a Chief Justice we take up the judiciary. We get one of the biggest problems then we in the face where now the shortage of judges then. If you not know, we don't lose a lot of judges then. Some then they will be don't die una siam na social media, some of una attend the funeral, if don't judges then they, and we get a huge number of judges then we don't retire. So they only make do with certain judges them. But waiting at the mechanism where it puts in place for I sure say cases are dealt with expeditiously. We need to look at delay. We don't get the term delay. We get expeditious trial. You understand? Now when it come inside, looking at the number of judges that we don't lose, and the one that we don't retire, and the one that we did, now in get a meeting with all in judges there and encourage everybody say, I think we all get for move from we comfort zone. You understand? So now you discover say judges at the High Court, irrespective of the cases then, whether they look at the High Court, you understand, they are also used at the Court of Appeal. So it can and restructure the whole system wherein they get two experienced, two Court of Appeal judges then, with familiar with the proceedings at the Court of Appeal, and it also gets one High Court judge where they can join the Court of Appeal judges them, and the same nine they replicate at the Supreme Court.
That one they don't bring any result.
A lot of results. Now you discover say instead of you struggle for set a team of 3, you get from the pool you the pick. That is one. And also the major result with that, irrespective of the fact that we they get mass outturn in terms of dealing with cases expeditiously, but in also the prepare judges at the High Court for let they get experience at the Court of Appeal. So by the time whether they appoint you or you are promoted to the Court of Appeal, the proceedings at the Court of Appeal is not strange to you. So those at the Court of Appeal where they sit now the Supreme Court, by the time whether they appoint you for going at the Supreme Court, you don't get wealth of experience. So it's not strange to you.
So you use this medium for say since you come up, since you take up office, never be a time again we see prosecution or defense on closed cases, still magistrate or judge and delay for a past judgment in any kind of case.
No, in fact, if una can watch the rate of judgments the way we they deliver, when they go into public domain, you will discover say there has been marked improvements. You understand? Because of this approach, there has been marked improvements when you look at this approach, and it's just because it gets limited number of judges as compared to all the Chief Justices them of recent past.
Right.
It get limited number of judges them, but it's like because of an approach, an inclusive approach into every layer of the court, make we they get a very affirmative outcome when it comes to sitting of cases, when it comes to delivering of judgment, and when it comes to conclusion of cases.
All right. One thing we don't emphasize this morning at that una no get better judges at this moment. Almost judges una get.
We get less than 35 judges then. Less than 35 judges then. And for we, it is very, very huge. Now, if you take the statistics of Sierra Leone, even when we get 40-something judges, you will discover that we get 120,000 people to a judge. When in Ghana, if you look at the statistics in Ghana, you get 22,000 people to a judge. So basically, we need judges then. And when we come to the issue of the criminal session, then you will see the reason why government or civil society or whosoever want for ensure say we move with cases expeditiously more than how we deal with them. So for advocates, for let we get more judges then.
Alright, Justice Combat Commander, we come for your name way back from Reverend Matikwati. We made a report na court during intending the Radio Democracy. And over the past year, concern we don't come out from the media, especially people with the report na court na that they not get access at times for meet with the Chief Justice. How different Justice Combat Commander be in terms of access if the media want to talk to them?
Okay, it's universal that judges normally need to get direct link with the media. and not ever feel saying me experience. We don't see outside they get direct link with the media because they are restricted for comments on a matter. Because for any opportunity where a judge gets for talk with a journalist, now for ask them about a matter, what you think about this matter.
At times, not also for think, but discuss the way forward.
Well,
in terms of the welfare of the media,
yeah, so that is why we get the communication team. But we all know Justice Kombakamanda as somebody way friendly to the journalists them, and since in take up office, I can tell you because I've been the link we are in, it don't meet full term with the executive of the Court Reporters Union, not generally the individual journalist them, but it don't meet full term, and we don't get fruitful discussion when it comes to the issue of court reporting at this country. Recently, we get a workshop of the court reporters, the first workshop, and it play a very key role for ensuring we improve the standard of court reporting now this country. So it gets a very affirmative relationship with the court reporters. But notwithstanding that, when he want communicate to the public and he want communicate to the court reporters, we always serve as an interface between the Chief Justice and the court reporters then, and any other journalist.
You don't talk about the Chief Justice in your plans and for the judiciary be effective in the service they render to salon people. Let me go again in all of this. One thing very important, if this all for upon the independence of the judiciary, where somebody go on for ask routine or how the Chief Justice when they manage that one day.
Okay, that's now provision of the Constitution, section 120, subsection 3. It make and clearly say in the performance of in duty, not the duty of the Chief Justice, the institution in common mandate within section 120 subsection 2 say we for deal with criminal and civil matters then, and matters then we parliamentary refer to us. So when we perform that function in subsection 2, in the process of section 123, we for be subjected to the Constitution and the laws. You understand? So when it comes to the issue of the independence of the judiciary, people like you always raise concern. Say you think say the independence of the judiciary we are independent, and some can even term say because the president they appoint the Chief Justice, so as a result the judiciary is not independent. That's provision of the law in the Constitution, and then they talk about the Chief Justice, and they talk about every judge where they preside on a matter. Once a judge they preside on a matter, for you for be independent and impartial in dealing with that matter, they are very, very crucial. And you also therefore be very, very independent, look at the law, subjected to the law and evidence. Okay, I think
then I would supposed for be bonus so it be.
Obviously, every judge is subjected to the law. If you take a decision, you understand by your interpretation of the law, you understand, and how you look at her and how the evidence flow. If you are not satisfied, that is why for project the independence waiting happen back, we get a appeal structure. If a decision at the magistrate court is taken, you're not happy with the decision, you they come and appeal at the High Court, and the High Court judge is more senior in experience and in years of court now the institution, a more senior and experienced than the magistrate. So if the High Court judge give a judgment you're not satisfied, you they come to the Court of Appeal. And the Court of Appeal, if you then give judgments when are 3 experienced judges that you're not satisfied, you they come to the Supreme Court, wherein you get the most experienced judges then. But one thing will for them matters then, other than matters of human rights, you they discover say the Supreme Court now the final Court of Appeal. So you they see the independence, you understand, in run through. But every judge and magistrate, when they take decision, they look at what the law say. Then look at now you they come into the court with the law. If they say you don't commit an offense, the law tag that as something very wrong or insane as something very good. You understand? So when you come, the judges then they look at the law. If they do interpretation that is not fair in accordance with the law, then obviously you get a appeal structure. But other than that, every case where we deal with, somebody there where they lost, somebody there where they win. And you cannot determine the independence of the judiciary because you feel say you for win the case When other person don't winner, you say no, we are not independent. Because we need to look at law of truth, we need to look at law of evidence and the facts. Now we subjected to. As you see that section 120 subsection 3 say, we are subjected to the constitution and other laws, not in public opinion, not in public view.
One thing people don't they allege now that when they get order from above for do some of the cases or pass verdict on some of the cases. Is it true?
We need to get order from above with decisions are not based on orders from above. As you may say, we dey get orders from above. We don't need for sit, we don't need for proceed in cases that we don't need for call witness. But if we dey do all them things, then they, because it is a set down procedure and our decisions are taken in accordance with the law and in accordance with evidence.
So we're thinking different because, for instance, somebody go get this case, or party A they get this case, party B get similar case, but this person will go, then go grant and bill other person, and the bill measures when they give perhaps a more stiffer than the other one.
No case, no the winner the same. It's very clear.
In terms of the charges,
not case, not the way not the same. The charges they can be the same. Let me give you a scenario. Now, me and you, they make palaver, or you can't. Let's say they make palaver. You hit me, namiyai. You understand? Are they with nef? With me, are they with nef? Then another person come, he hits me, namiyai. But the nef then are gone. You understand? That case you might think saying are the same. Not to the same. Because are they in possession with the nef, or something I hold the nef, if I choke you, I not be get much opportunity. It might be say I not one with the intent. You understand? But that person when left Butuna go and take nef choke you, that makes the cases then different. So no case, no day win are the same. You understand? It might have a similar scenario, but they are not the same. So that is why you will see in certain case, then grant bail. Even when it comes to the issue of sentencing, the weight of the evidence, the weight of the intention, they determine, even though not the same choke, not the same slap, not the same sound as slap, but the weight of the evidence can determine longer sentence and shorter sentence. And we therefore make that clear because it is also one area where people like can use for judgery. And that is why in the bail and sentencing, we try to forget the bail and sentencing. Now, the current Chief Justice will now be also one key instrumental person will be involved into it. So I will say the bail and sentencing are in Peking. You understand? And that is why when it can in Olam with it one, the bail and sentencing, they try for address inconsistency when it comes to the issue of bail, when it comes to the issue of sentencing.
Right.
If you go into the bail regulation, it tells you there are procedure, there are bail documents there are bail conditions where every magistrate for follow. You not go out of the conditions then we prescribe now the bail regulation.
Right.
So now it make that issue of say fen imam we get registered mosque and not try for discourager. That we for go for thing once you don't grant somebody bail, the condition not for be very, very rigid. If you go say fen imam we get a registered mosque, it is difficult than producing a title deed. It's very difficult for them to produce house book. So in the try for discourage all them things, and that is why we are making use of ID card when it comes to the issue of bail. That ID card is very, very key because it is also recorded in the bail regulation.
Okay. Now, one of the things that you can for talk about this morning get for do with the criminal session, we don't start. But firstly, why the judiciary can organize criminal session and within a criminal session?
Okay, the criminal session na a provision of the law. If you watch at section 131 of the Criminal Procedure Act, it give power. Mind you, waiting the Chief Justice they do in the criminal session, so for set them up, for send judges them, for give them the power for go try and sentence now other areas then and get them by law. Not to waiting in field for do. And get them by law in the provision of 131 of the Criminal Procedure Act. Now the criminal session, now a session where they look at and people then where they don't get an indictment, waiting an indictment. Indictment are like a visa where they take it from one court to the other. Now the magistrate court get cases them where they deal with, where they can do summarily, they can complete them in their sentence. If the sentence not exceeding 5 years, the magistrate can able do one and sentence you. And there are certain times when the person can say, okay, we need for trial and completer, or we need for committer. But let us say in cases that like heinous offenses then, like for instance, murder, treason, robbery with aggravation, robbery with violence, lastly, there are other offenses that they, where upon conviction, the sentence they above 5 years, waiting they happen, the magistrate can commit an high court. So the mandate of the magistrate in dealing with their cases then they not just preliminary investigation, then it commit an high court, because the high court now a court of unlimited jurisdiction. When it even come for sentencing, then they deal with all matter of cases then. But for let you come on at the magistrate court, you go to the high court, for let them go try you and determine your case. Waiting they happen, you need for get an indictment. So this criminal session, they look at 174 cases then. 174 cases then. And out of them 174 cases then, yeah, we get over 200 people then accused they were involved. Because some cases there, you get multiple offenders and multiple accused persons. And out of this 174, we get 36 then, where they not be get indictments as per the 6th of February. They not be get indictments. And you get 38 where we get indictments. So what did the Honorable Chief Justice do is summon the head of the prison, you understand, and in summon the law officers department where they get the power for prosecute, and he also get the master and registrar and some of we senior staff there for all a meeting for watch in various prisons then, like na Sefadu Correctional Center, how many inmates then they will get indictment and will not get indictment. So the one that will get indictment, the prison supply we say they get 4 with indictment, 40 without indictment.
Ghana outside so.
Na Sefadu, na Kono. Then in Pujong, we get 47. All the 47 there, where they don't commit na high court, they don't get indictment. So if they don't get indictment, then they will spend so many times in prison until they get indictment.
How comes they can go prison without indictment?
No, the indictment, you don't complete the case at the magistrate court. Then the magistrate court say you get case for answer, but this case I not get power for determining now the high court. So it's a transition. You come up from the magistrate court, you go to the high court. It's a transition period. So
now that responsible for issue out the indictment.
Now we get is a collective effort.
So now that responsible.
We get the judiciary, we get the law officers, we all they come together. So when there's someone anything they are so, when there's someone we get the set of people there so where they all now where they appear before then judges then now the various locations for the criminal section they have been served with an indictment, and because with the intervention of the Chief Justice then people there so then they face the trial now at various locations.
Continue for all not to that list we can continue for watch at the list, but we go to do 2 quick and take this commercial break and we'll come back with the continue. So it be the talk before we take that commercial break there about 2 things na indictment, already shout indictment and self be the gear rundown of the different cases they want to go for look at inside this particular activity on the do. Continue from there.
Yes, just we talk about the collective efforts with the AG's office, the CJ, the judiciary, and also the prison legal aid when we put. But let us look at specifically waiting to be the input for let we get a successful commencement of the criminal session. The AG's office, that the minister, the Attorney General and Minister of Justice, they purely responsible for indictment. And frankly, they have done extremely well under your own leadership for ensuring they do a total of 136 people on indictment. Just imagine from February 6th till we commence on the 17th, where the session starts. Then you will ensure say 136 people within a prison get indictment for kind of high courts. You understand? So that's a kudos to them. And also they also send law officers, they also send lawyers them, prosecution lawyers them, now all them locations they also. Because for let we get an effective criminal session, you need to get defense counsel, where legal aid send lawyers them, we need to get a judge, where now the judiciary they send, and a court registrar, where now the judiciary a bailiff, where now the judiciary, and also for ensure say witnesses then come. Because in that terrains, then they will make provision for witnesses there as well. So that when somebody come, then go able to deal with the cases expeditiously. Like for instance, looking at Kono, we get Justice Eke Musa where they sit on, they currently is start on the 17th, and we get Justice Abubakar Sano where they sit on at Mabroka. So when you look at the number of cases then, because witnesses they are available, they will come and testify. They have dealt with a huge number of cases then. So by the time they say the 2 weeks they done, then we don't complete them. So we also be the talk about Maboka. We get 38 where they not be get indictment, and we get 20 where we get indictment. Then Kabbalah we get 7 with indictment, 6 without indictment. Then we get also we probably go Kailan, Pujon, Kailan and Bond, but there is nothing like in the cases that we will deal with here. But also, one thing we want to let people understand, because we can tell people and forgive them in terms of we list what we get, what are the dominant crime and in which area. When we collect with statistics, like for Sefadu now, Kono, we get a total of 44 people and when they appear before Justice Musa for various offenses then. But we look at key offenses then to where we can always say, let we look at the statistics. Murder and sexual penetration. We know say they're very, very serious, just like other serious, but they are then we pay more attention to them. In fact, globally, there is no crime that is more heinous and serious than murder. Murder Nakono, we get 8 murder cases then out of 44. Now Kabbalah, we get a total of 13 cases then, and we get 7 murder. So the one then when they do statistics, they will tell you that Kabbalah, despite they get 7 with 13, they can take the lead in terms of murder cases then. And for sexual penetration, Kono, we get 10. And we get small Pikine also where they penetrate. We get Kabbalah 1. In Cambia, we not get any case of murder, we not get any case of sexual penetration. But we get housebreaking and other offenses then. Pujon, we get a total of 47. We get 1 murder case. We get 1 sexual penetration case. So for this session, out of the 147 where we did 74 where we did look at, we get them people that we did try. Some of them they kill a total of 16 people them in the 5 districts they are so. And we get picking them when at 12, a total number of 12 picking them, where the one them where we charge for where they try for sexual penetration do with 12 picking them, and we get 16 people them we don't lost their life through people they earn.
Alright, now you just give a different statistics of cases. When I give them any time frame and almost cases when they are assigned per judge. The reason why I asked that we don't get concern from the public, civil society. To be specific, Abdul Fatoma, we are in a right owner say they want to know the total number of cases when they are assigned to judges. But you say up till now, una no get back onto. Una receive any letter from her?
No, we do receive letter from Fatoma, and I think say we were fair enough for communicate to Fatoma. How the judiciary they operate every day, cases are assigned. Now, if you go, for instance, if you go to the supervisors then for the magistrate court, either to Justice King or Justice Barnett, you they find out say more than hundreds of files then we don't come in just for magistrate court.
But when I explain, you understand say that this is the situation.
We'll explain to Fatoma and we'll explain to the general public. So in addressing the issue, explaining issues of concern to the general public, it means we have also communicated to whosoever want the news. You can send in a request for an information. If we communicate to the general public, it means we don't communicate to everybody. The statistics of the judiciary, they go up every day and they reduce every day. Now, let me tell you, if the Chief Justice or whosoever that is responsible for assigned cases then, if they assign 20 days, you understand, it might possible say, by the time where they come, 5 don't go free. They're not there now with system again. And tomorrow, 100 don't come. By the time they remember, so for get track of we records that we go tell you say, in we returns, we able to tell you say for the month, we go able to give analysis on a monthly basis, you understand, or on a weekly basis. For say inside this week, by Saturday, we able to say 300 cases then come inside, and out of these 300 cases then we don't 4 don't come out, 10 don't come out, but you cannot tell us for say how many cases are assigned to a judge, because the assignment is every day, every seconds, every minute. Cases are coming up for assignment.
But why una not get the data with you and explain here say every day we get cases by time?
No. What he was asking for, a case to a judge. Get waiting they ask for a case to a judge.
So the judiciary not able to.
So we have explained to the people, and I'm pretty sure the people understand. Say we need to able give a statistics for the day, because we they reduce and increase. Anybody who wants a monthly statistics, we can give it to you. Anybody who wants a weekly statistics, we can give it to you per magistrates and judges. But we cannot give you a daily, because if we tell you now say na 10 we don't get to judge for day, it's possible say the judge where they assign cases for the high court go don assign another 5, 10 or 15 file to that magistrate. So it they come with inconsistency, and that we cannot deal with the people. So in as much as you want information, you cannot ask us for an information where they put with credibility down. If anybody needs information on a weekly basis by a judge or a magistrate, we can provide it for you. On a monthly basis, we can provide it for you. Because let me tell you one thing, one good thing where the Honorable Justice Commander do as well now for ensure say the return system is effectively, in fact, in time bound for coming, so we get a very effective statistics.
Inside the program, we still get the official spokesperson for the Judiciary of Sierra Leone, we now Moses Lamin Kamara. It updates we about the vision of the new Chief Justice, Justice Combat Commander, and same way so don't talk about the criminal session. When actually this criminal session start and when it go down?
Okay, it starts on the 17th.
Where we
start with this month. We start with 2 locations then. We start in Mabroka. We get Justice Anode. Justice Anode, the resident judge, the newly assigned resident judge Namakini. Na in the cover Mabroka. So in the deal with a total of 58 cases then. So in the take 2 weeks day, in the end on the 27th of this month, and Justice Ike Musa de Nakono in the deal with 44 cases then, and in the end on the 27th of this month. Okay, when Justice Ike Musa done, the second phase they start on the 27th and it extends to another 2 weeks. So the only thing Justice Ike Musa they get 14 days for 1 month. When come out, they go Kabbalah, now they go preside na Kabbalah, and they go deal with 13 cases then they, and the Honorable Justice Banks Kamara in the dinner Pujon in the deal with 27 cases, and you get also Honorable Justice Ball in the can Nakambia, and Nakambia in the can deal with 13, in the can deal with Kambia in the can deal with 12 cases then. So basically that makes the total of the cases then where we look at we now 174 cases then.
The whole idea of this now for make sure say for decongest the prison them and make sure say cases them go smoothly and fastly. But again, watching at one judge, they watch at something like 57 cases inside 2 weeks. So I think say go able for like get the desired vision on the envisage.
Yes, the principal vision, in fact, this day into the strategic plan for the justice sector, you understand, wherein we say access to justice, wherein you get the court. The court, it means the judges, the judge or the magistrate, specifically they'll say this, the judge, the law officers departments, the legal aid. We go meet the people in the community, and why we feel say a very achievable now the fact that the people then, instead of like the kind of McKinney, you understand, like from Maboka, I will not get a resident judge. In all of them places there is no resident judge, because of which I'll be telling you now the challenges them with the Honorable Chief Justice face. So using them judges there, so they also get workload them now other locations them. Boss did they go sit down at that place there. Instead of you can and McKinney, we come on Maboka for can deal with cases then. Now if somebody and a witness in not get money for can pay, where you can go na McKinney, you can go na Maboka in more expeditious for there than deal with the cases than they because it's proximity and take the principle of proximity. So we first aim now for ensure say we create access to justice, but also we also take into consideration the aspects of human rights. You understand? Because we not assuming say then 137 people like they not be get indictments up till now. Even if we send a judge, let me say if the CJ be restrict and say okay, let me look no more at the 38 we get indictments. It means then people are then for then are then locations there so they not for become appear before the judge. There is possibility. We aim is not the principal aim is not to decongest because the law determines who you should release and who you should not release. Right. There is tendency say the evidence will go show up for all them 174 a huge and compelling on the judge for sentence them all. There is possibility say the evidence they are so weak that 100 will be set free. So then they determine on the law and the evidence. But the essence now for ensuring we create access to justice and we address the issue of human rights. If the congestion of prison move in accordance with the law and it move in accordance with evidence, then obviously we can also take it as a consideration as something that we achieve. But it is not the principal aim of conducting the criminal section. It could be one of the sub aims then, but the principal aim is access to justice. Okay. And the other one close to that is expeditious trial for them people that are within a places also will not get a resident judge.
Inside the program we start for look at messages. This one say please Mr. Moses, please update us about the case of Abdul Parker.
This other person, we not on the Scott now with Facebook page, they say the judiciary should be the most independent institution in the country, but there has been no case. That has not been the case for the few years. We have witnessed the removal of elected members of parliament from the opposition, countless injunctions to stop opposition activities. That should not be the case where we have an impartial and independent judiciary.
This other one we are going to take is Mr. Piero of Judiciary. I had a matter in Justice Brown Mark's court which was adjourned for verdict since 2010, but verdict has never been given till he has retired. What is the way forward for this kind of injustice?
These other comments from Mystics Nadwazak, they say public trust is vital in the day-to-day operations of the judicial sector. The judiciary in Sierra Leone should try and build up public confidence, which is still missing.
This one from Mark 10, New Englandville, is say even though there are challenges of enhancing access to justice and improving court efficiency, confidence Justice Combat Commander will be committed to collaborate effort with judicial stakeholders to address them. Come out from Martin and
this from Raymond Alpha, they say what is the marks of cases allocation to a judge that must not be exceeded regardless the highs and lows, as Mr. Kamara stated.
This one from Emmanuel say I have no doubt in Justice Combat Commander, he will deliver.
This other person when attending this court also, they say the past APC administration did well by establishing the Ross Road and Pademba Road Magistrate Court in Freetown to reduce the burden on the main court building. The biggest challenge we face now is access to justice and impartial judiciary, more so when it has to do with members of the opposition.
This other one from Stevens is say, Mr. Kamar, please update us about former President Kurma case and also Mohamed Kamarimba Mansari.
I think we get a couple of them messages and then at the inbox. Mr. Kamari go take note, and we also continue to look at more text messages where they come up from Mark 10 and England. So I wish to express gratitude to the President Bill for the trust placed in Justice Combat Commander. I strongly believe he will uphold the principle of justice, fairness, and equality. The judiciary is a pillar of our democracy, and Justice Combat Commander is committed to ensuring its independence and impartiality.
Last one I will take from Ayo Jonathan Williams. He say the court is a place to seek refuge, but
I think Usman will then text message and they will come back to the studio guest as he will reply.
Yeah, one for say thanks to all those who really compliment the efforts of the Honorable Chief Justice, and we also want for comments on. We also appreciate those who then send critical comments. Them, we know say we need for look at them. Obviously, somebody says the issue of public trust. They grow up within the judiciary. That is very true. We don't get with the access because even with the number of cases, with the access because somebody can decide whether for gay in case court in case narcotics or not. But with the cases that they come up with, say there is an increase in public trust. That is based on leadership output. And somebody talks say and get a case we reserve from judgment from 2010. I want to encourage that person let him come meet me in the office. He asks for we office the communication office. He can meet anybody and we can try for trace this thing or talk with the judge for know waiting about the status of that case day. You understand? Also somebody say, well, notwithstanding the constraints then we the face as a judiciary in terms of judges them, we not forgive workload for where they exceed. That will not forgive too much cases then to judges them. Yes, we agree. In fact, for me, this person so concerned. Judges are human beings. They get family, they get them wife, they get them picking them, they get other commitments. But it's like the rate at which our judges are working today from the Supreme Court taken down. You know, when you know it's very, very we will say we want to appreciate them because with the number of cases there is so huge for them. You grab the net, you will see George the online, you will see the research, you will see that they write you flash one self na net and don't pick and for response to you. Yeah, we understand, so we want to tell this person say una being go advocate for let we get judges them. But one thing we are the tell una that we did in the process of recruiting judges them. And we only hope say governments go give we a number because we get them from finance, say the provision day, the money day for insurance for take care of them, salary. We feel say they will able to give a huge number of judges then because we need them.
How much number on a need now?
If you can ask the CJ, he needs as many as possible. Mind you, before now there was a judge in Kono, a resident judge in Kono. We be get a resident now. Kailan, the judge in Kenima, Justice Sharif, we don't assign it. Now you get for the go cover Kailan. Then now you get Justice Justice Sano get for the cover Kamakwe. So we need judges then. That side is very clear. In as much as we need magistrate them, but we need judges them more than magistrates as for now.
Okay, continue for look at the text messages and make I draw your attention again to the one they get for do with Anesco, former president and Sef Kamaremba. What's in the status of the case?
Okay, let me just say for Kamaremba, we all be know say Kamaremba began a case of which he was convicted for sexual penetration. And he was sentenced by the Honorable Justice Taylor. And that's the beauty of judiciary. Now in appeal in sentence, say this sentence in the appeal. So within the process, we in Medina prison in the seek and request for a medical support out. So we feel say it don't do enough and we don't complete the files then the bundles them because you get for collect them, pack them and give them also like 3 judges them. You get for watch each one gets in copy from the start of that case. Say to also enrich. You understand? So we don't complete that in the end. When we complete them, we send a notice 2 days ago to the law officers to the state. Because now here in the state, then we send to in lawyers them. So today that matter they come up. You understand?
Almost a medical leave on Amigi Kamarimba.
Well, we be give leave way in better and we feel say it don't better.
So in no time frame no mean they say okay, we'll give 1 year after that you come back.
Yes, we feel say it don't better once because it's ample. Once we don't complete the file, we feel say the case don't prepare for hearing that. And let me also make this thing clear. The judiciary, when they appear before the judiciary, we not get they call on honorable this, we not get honorable, we not get minister. We call people and when they come before the court by the names them. So we don't know who than a politician, we don't know who than a reverend, we don't know who than a bishop. So once you get the case before we call you by your name and we treat you as you come and as the law say we for treat you.
Okay. Usman?
Plenty thank you for joining inside the program this morning. In name now Moses Lamin Kamara, in the official spokesperson for the Judiciary of Sierra Leone, as I'm in there this morning for talk about the criminal session and save lot of issues them we don't they happen na the Judiciary. Plenty thank you Moses for joining inside the program this morning.
Yeah, thank you.
When I good the content of the program, good morning, Salon. We come to you live from Radio Democracy 98.1 FM. Plenty thank you to producer Michael Sambola with support from Mangeman Sari and Kabia. Plenty thank you to John Kamara, DJ Sugarcane, Fatimata Samura, and Mary Kamara Bangura. Make us see you live on Facebook. So to meet another 10 million Busman Kamara. Have a wonderful day. Bye bye.
And your name na Chango Jalawede. Don't forget for listening to we midday show program at 12, Salon News at 7 p.m. and 9 o'clock na net. The program will be to come to you with different issues. So today, then, tata.